Hi everyone, my name is Bazikyan and I'm a trust and estates attorney here in Los Angeles, California. And this month I wanted to talk about a topic that comes through my office very frequently actually. So a lot of times people will come into my office and they'll say, I want to gift my property to my son or daughter. I don't want to do an estate plan, I just want to give it to them now. I trust them, let's just deed it over, quitclaim deed it over and be done with it. And so I want to address in this video 3 negative outcomes of giving away an asset to a beneficiary or a loved one now versus in the future when you pass away. So the main negative outcome or consequence of this act is control. When you quitclaim your property to another person, you are no longer the legal owner on that property. So let's say Sally lives in her home and that's the only thing she has. She has a home. And she's thinking, well, I only have one kid, I only have a daughter, why am I not just giving it to her now? Let me just transfer the deed to her and be done with it. I don't have to worry about probate. I don't have to worry about, anything that comes up in the future because I'll know my daughter has it and I'll continue to live in it until I die. So in that scenario, once Sally quitclaim deeds the property over to her daughter, she is no longer the owner, which means her daughter can sell the property without telling mom. She can kick mom out and do all of those bad things that we don't really envision our kids doing to us, right? A lot of people go into this very optimistically. So that's one thing to consider, is that you no longer will have legal control of the property. So you're going to be subject to your child and whatever it is that they want to do as far as choices are concerned. They can mortgage out your property. They can do everything and anything that a property owner can do. A lot of times people are not too concerned. They'll say, oh, I trust my child completely. I'm not worried about them kicking me out when we have this discussion. And my response is, you trust your child, but I also want you to take it a step further and worry about the future relationship with your child. So you're okay now, but that relationship might not be the same as it is today as it will be 10 years from now or 20 years from now, when your child, let's say, marries or remarries, and all of a sudden there's a spouse involved that you don't get along with, or for whatever reason you don't trust. So that's something to always take into consideration, that you might trust your child 100%, but there might be another person involved in your child's life that's influential to that child that you might not necessarily want involved in decisions regarding your main home. Further, if there is somebody involved in your child's life, like a spouse, essentially what you're doing is putting your home at risk within their marriage. So even though, let's say, you transfer it to your daughter and she owns it as her sole and separate property, if there's a divorce happening with your daughter and your son-in-law, there's going to be a likely chance that your property is going to be subject to their divorce. It's going to be involved in their divorce proceeding, but there's a chance that your son-in-law might come after this property and say, yeah, you know what, I made improvements to it. There's a certain percentage ownership interest that I have in that property. So you're putting yourself at risk, especially if you're of the age that you're retiring, that you cannot afford to go live somewhere else and to purchase another house or to live in another place paying rent or whatever it is. You depended on paying off your mortgage and living the rest of your life rent-free, mortgage-free in this home. So be very, very cautious about this type of transaction for that reason. Secondly, you are going to be opening up yourself to your daughter's creditors or your child's creditors. So in that scenario, Sally is a great human being. She doesn't cause harm to anyone. She pays all of her credit card debt on time. She doesn't have any outstanding creditor issues. Once she transfers it to her daughter, all of her daughter's problems are going to now become her problems. So let's say the daughter is also an equally great human being, but for some reason she was not very attentive while driving and she causes a car accident. And now she's involved in this crazy lawsuit where somebody passed away. Once the daughter is subject to that lawsuit, all of her assets that are in her name are going to be subject to a creditor's claim, essentially. So what you're doing is you're putting your home that you worked very, very hard for throughout your life to pay off and live in for the rest of your life at risk being a part of your daughter's problem. So that's huge. That's something to consider when thinking about gifting something versus putting it in a trust and allowing your child to inherit it. And the third main negative consequence of these types of transactions is the step-up in basis, which we've talked about in previous videos. And essentially, inheriting an asset through a trust is always going to be favorable when it comes to capital gains taxes versus gifting that property away. So let's play this out. Let's say you bought your property in the 80s for $100,000. You've paid it off and you're trying to figure out, should I gift it to my daughter now and just transfer it into her name, or should I create a trust, put it in there, and then she can have it when I pass away? So one thing to consider is capital gains tax. If you gift it to your daughter, let's say in 2018, and at this moment it's worth $1 million, your daughter's step up for capital gains purposes on that property is going to be what it was when she actually took title to the property. So after you're gone 20 years later, she goes to sell the property and it's gone up in value. All of a sudden she's going to have a hefty capital gains bill to pay to the IRS, versus if you had kept it in a trust and she inherited it, she's going to get stepped up to the date of death value on that asset, and so likely her capital gains tax is going to be very minimal at most. It's definitely not going to be what it would have been if you had gifted it to her. So check out the previous videos. They're on our website about step up in basis, because that'll help you understand what a huge tax disadvantage this is for your child. You might not care. You might say, whatever, let them pay for it. It's not my problem. I'm going to be gone by that point. But it really is something so significant. Why should, you know, a couple $100,000 leave your daughter or your son's hands when it can go into their pocket? Why should it go to the IRS when it could have gone into their pocket if you had just thought about how you're going to do this transaction, or at the very least just sat down with an attorney to explore the different options? Feel free to call our office if you want to sit down and talk to me about it. If you're thinking about gifting and you're not sure if it's the right step, sometimes for some people it is truly the right step to just gift it to a child now versus waiting. But for most people, with all these other considerations to take into account, it is definitely wiser to sit down with a legal professional, call our office. We offer free consultations, and we'll kind of walk you through and explore the different options and whether it's a right fit for you or not. So feel free to give me a call. We provide free consultations, and I look forward to meeting you. Bye-bye.